Good morning, everyone. Tribunals and their proper place in Indian dispute resolution machinery have long engaged our jurists and lawmakers, and indeed the Honorable Supreme Court of India through several cases over the past 3 decades or so. The decision in Rojer Mathew versus South Indian Bank, delivered in November 2019, stands last in a long line of important verdicts that explore critical questions, such as the constitutionality of parent statutes that create such tribunals, the permissibility of overriding judicial review, particularly when it comes to the writ jurisdiction of high courts under Article 226 of the Constitution, the conditionalities to be followed by laying down the manner and terms of appointment and conditions of service of these tribunals and its members, and the vesting of authority in respect of the overall superintendence and control over their functioning, as well as financial matters connected to the same. Despite these precedents, Rojer Mathew is a special case because of the special circumstances in which it came about. Through a money bill, several tribunals were abolished and their functions merged with existing tribunals in 2017. There was scant data or factual basis to perhaps defend the policy, and the action taken was quite sudden. But let us take a pause here before we hear from our distinguished speaker for today as to how the Supreme Court has addressed this issue and the way going forward. Good morning and a warm welcome to this edition of Daksha Dialogues. I am Anant Padmanabhan, Dean at Daksha Fellowship, and it is my delight to introduce the Honorable Justice Deepak Gupta, our speaker for today. An alum of Delhi Law Faculty, Justice Gupta had a stellar career as a practicing lawyer in the Himachal Pradesh High Court before he was appointed a permanent judge of this court in October 2004. He headed the green bench of this court for more than 3 years and was the first judge in the country to impose damages of rupees 100 crores in an environmental case. Justice Gupta was elevated as the first Chief Justice of the High Court of Tripura in March 2013 and subsequently served as the Chief Justice of the High Court of Chhattisgarh. He was elevated as Judge of the Supreme Court of India in Feb 2017, where he was part of the bench dealing with environmental and social justice matters. He has also headed the committee to oversee the proper and effective implementation of the Juvenile Justice Act of 2015. Justice Gupta retired from the Supreme Court very recently on 6th May 2020 and was the first judge to receive a virtual farewell on his retirement. In addition to law, he has several other interests and he is fond of reading, walking, and is an avid photographer with keen interest in landscape and wildlife photography. Today, Justice Gupta will address us on tribunals in India, independent judicial bodies or extended executive arm, extrapolating from his part dissenting verdict in Rojer Mathew versus South Indian Bank. Before we begin this session, I would like to remind you that all participants in this session are on mute, but you can post your questions and queries in the Q&A tab and we'll take them up at the end of the session. Finally, a word of appreciation to Live Law for partnering with us for this conversation. On that note, over to you, Justice Gupta. Thank you.
Thank you so much, Anand. Very good morning to all of you. The topic today is I would reframe the topic as tribunalization of justice. See, when we adopted the Constitution on 26 November 1949, which was formally came into force on 26 January 1950, we promised to ourselves, the first promise which we, the citizens of India, held out to ourselves was a promise in the preamble to secure to all its citizens justice, social, economic, and political. So justice is the first promise which was held out by the founding fathers to for the citizens of this country. And when do you get justice? You get justice only when there is a totally independent judiciary. The high courts and the trial courts were handling all sorts of cases, except there were some income tax tribunals, etc., which were already working. And I am not against setting up of tribunals. I like to make it very clear. But it is which tribunals should be set up, why should they be set up, and how they should be met. Anand, I may not agree with you in the sense that I'm not going to do an analysis of Rojer Mathew's judgment because I don't want to do that. because mine is a partly minority judgment, and to say that I am right and the others are wrong, it would not be fair. I am in the minority too, but I'll talk about what I feel is the way forward, not in the context of the judgment, but otherwise. Now we must remember that Article 323, which talks of tribunals, was brought in during the emergency in 1976. This was basically initially meant for administrative tribunals and then for certain other taxes, rents, etc., tenancy matters, which some of them may require tribunals. There is, in this fast-growing world, today we have the internet, tomorrow we may have something more, space age, medical terms. We need to have specialists, and though as judges or lawyers, we may be jack of all trades, we can't be specialists. So in certain cases, we will need the assistance of people who really know their job. And therefore, I don't think tribunals can be done away with. But tribunals to what extent? Should tribunals be constituted only to take away the burden of the courts? In the beginning years after 1977, especially when Justice Bhagavati was there in the Supreme Court, the court was very pro-tribunals because it felt that a lot of burden of the courts could be taken away by these tribunals. Today, we are faced with a total burden of more than 3 crore cases in the entire country. Our sanction strength of the district judiciary is hardly 21 or 22,000. I had an occasion of interacting with some Egyptian judges in the National Judicial Academy at Bhopal. And Egypt has a population of 10 crores approximately compared to our 135 crores. Economically, I think we should be more powerful than Egypt. We should have, and they have 17,000 judges for a population of 10 crores. And our population is just almost the same for 135 crores. So I don't think tribunalization is the answer to everything. I think you have to get more people into the judiciary, both manpower and infrastructure has to be increased. And then if the judiciary still cannot function, then maybe we have to look at alternates. But as I said in the beginning, there are certain branches, taxes, etc., where tribunals may be necessary. But even where tribunals are necessary, I am clearly of the view that judicial review, which is now accepted to be part of the basic structure of our constitution, cannot be taken. Now, this has been done in various ways. And one of the ways is to give an appeal directly to the Supreme. Now, there are more than 20 statutes where an appeal is provided directly to the Supreme. In fact, there was an interesting case which I decided first that the full bench of the Supreme Court also, where the Chhattisgarh government made the challenge to the rent control tribunal, appellate tribunal, only appealable to the Supreme Court. So we have the state has no power to do this, but this is the way people think. You see, this Supreme Court should not be dealing with these cases. We should be more of a constitutional court. And if every appeal comes to the Supreme Court, it will not be proper. Therefore, you see, what is our country about? It's about separation of powers. It's about the rule of law. And when we talk of the rule of law, which is the golden thread which binds the constitution and the polity of this country, if there is no rule of law, there will be anarchy. If there is no rule of law, we will be ruled by the whims of a few men. And I think our democracy is a vibrant democracy. We change parties, we sometimes don't change parties. I may agree with one person in power, I may not agree with another person in power, but that is the will of the people and we have to accept that what is the will of them. Having said that, I'll say across the board. It's not A party, B party, C party. Whoever is in power tries to have control over the judiciary and the adjudicatory bodies. We must accept this as a hard fact because they don't want a judiciary which decides against them. They'd rather have a more pliant judiciary. They'll do everything, whether it's appointment of judges. So they find it very difficult to do it in appointment of judges. So how do they do it? By tribunalization of the courts. Now, when you have tribunals and we become a country of tribunals of retired people, almost all tribunals, barring a few, have only retired people in them. Retired judges, retired bureaucrats. Now, we can't let our tribunals become clubs for retired persons, because that is not the proper way. I have said it in my judgment, and if these people are good enough to work after retirement, then why can't they continue to work as High Court judges or Supreme Court judges? We have a vacancy position of almost 35-40% in the High Courts. If you increase the age of the High Court judges to 65, make it equal to that of the Supreme Court, then for 3 years you will have no retirements, and if you make appointments, your vacancy position will improve a lot, and you will have experienced persons still in the High Court. When we talk of impartiality of justice, I also feel that the age of retirement both of High Court judges and the Supreme Court judges should be the same. They both perform exactly similar duties, and I don't see why a High Court judge should retire at 62 and a Supreme Court judge should retire at 60. And I think it will take off the pressure for many High Court judges and also a lot of other pressures which I don't want to talk about here. But it will make, I feel, it will enhance the stature and the independence of the judiciary if we have a similar retirement age. The argument raised against that many times is that then nobody would like to come to the Supreme Court. I know Chief Justices would normally not like to come to the Supreme Court because as Chief Justice you have so many perquisites and you're like running the judiciary of the state, and if you're not going to come within the collegium or something, you're just another judge in this. But I think we then have to make selections on the basis of choosing the more people who are more administratively capable become Chief Justice of High Courts, because their administrative capability is an essential requirement of a Chief Justice. And as far as the Supreme Court, those who are more intellectually inclined, they could be brought to the Supreme Court. It could work beautifully, I think, if the right appointments are. Why am I talking about this in tribunalization? I mean, you think I might be veering off from the topic. I am talking about this because I feel appointing judges to man tribunals is not the right. We can't do away with it just now, because right now we don't have anybody else. We can't pick up somebody from the bar and straight away appoint him as a chairperson of a tribunal. But if we increase retirement age, make it equal, say that there will be no job after retirement, no post-retirement sinecures, whether in any tribunal, then we would be in a much happier situation. Now, coming to tribunals, why do I feel that tribunals have not helped in a large way? My state, I come from Himachal Pradesh. It was one of the first states to set up an administrative tribunal, somewhere in 86 or 87. And why did it set up an administrative tribunal? Because the Chief Justice was a very tough Chief Justice, Justice P.D. Desai, who wouldn't bring any nonsense from the government. And so the government decided to form a tribunal. Now, I remember in that tribunal, High Court cases filed, writ petitions filed in the High Court in 78, 79, maybe 6, 7 years old or 7 years old, which were ripe for hearing, went to the tribunal, and somehow they got numbered late and all, and they got. The tribunal was abolished about 15, 20 years later, and those same writ petitions came back. Some of them, I'm not saying all of them, some of them came back undecided from the tribunal. The tribunal was again established after 5 years. Again, some of those cases went back. It was recently again abolished. Now, if we keep abolishing and re-establishing tribunals, that is not going to be the answer. Administrative tribunals, tax tribunals, I think, are necessary. And they function very well. You see, by and large, our income tax, six tax, all these tax tribunals have functioned fairly well. The reason why they function well is that the recruitment to this tax tribunal is not done from retired personnel. It's by and large done from the bar or from the income tax services, etc. And they come it at a younger age when they feel they have a lot more to go. They could have end up as members of chairperson of the CBDT, etc. So they, that there is that vision of working, that feeling that if I can do something for my work and for the country and work. There is one other tribunal which has worked quite well, I feel, that the Central Administrative Tribunal. It has worked fairly well. And though it has some retired judges, I know there were a lot of lawyers initially also appointed to it as judicial members. At least I know of 2 lawyers from Simla who were appointed directly as judicial members. I know of 1 or 2 from Chandigarh who was appointed as judicial members, lawyers. And one of them at least came to the High Court also as a judge from becoming a member of the tribunal. Even as you know, all of you are aware that even from income tax tribunals, some people have been brought to the High Court. Even recently, somebody in Tamil Nadu or somewhere. Now, the issue is, why are these tribunals doing well and others not doing well? I feel that where you have a long tenure for the members of the tribunal, they'll do well. But what the government did was to abolish all tribunals. As I told you, I'm not going to talk on the merits of that case. It abolished all tribunals by a Finance Act, which we refer to a larger bench. And the bench also felt, which I didn't agree, that this judgment in Chandra Kumar also should be considered again. Anyway, I really feel that there have been so many judgments of the Apex Court laying down the requirements of what should be the requirements for a tribunal, members of a tribunal. R.K. Jain versus Union of India, L. Chandra Kumar, Madras Bar Association, 2 cases, then Gujarat Urja Vikas Nigam, and then Rojer Mathew. So many cases where the Supreme Court day in and day out lays down that if people have to have faith in the tribunals, then you must ensure that the tribunals are manned by people who can command the same respect as is commanded by judges, whether of the High Court or of the Supreme Court. Tribunalization of justice, in my view, also has an adverse effect. I'm not saying to a very great extent, but does have some adverse effect on the independence of the judiciary also. Because some of us compromise to get into tribunals. It's a post-retirement job. Now that must be avoided, and therefore I feel post-retirement jobs, this is my personal view. I'm not saying some of the people have done fantastic jobs after retirement. And there are some, not tribunals, but some institutions which will have to be manned by retired judges. Human rights commissions, National Human Rights Commission, the Lokpal, etc. Because there the people will not have faith if somebody else is about. But my suggestion for tribunalization is that there should be like the system being followed in the UK, where there are a lot of tribunals. You have a 2-tier tribunal. A 2-tier tribunal, meaning a tribunal at the basic level, which could be, say, similar to a district judge or something. Selections are made by an objective written test and nothing else. And then you have an appellate tribunal of that sort. Now I'll just give you an example which I've given in the judgment also, that you could combine various types of tribunals under one umbrella. You could have all the tax tribunals under one umbrella. You could have all the service tribunals, whether they are state services or central administrative services, armed forces tribunals, because you need, in all of them, you need, at least for the judicial member, is to have aptitude for service law. So these service members come from a particular service and they join maybe at the age of 35, 40 with a career prospect of retiring as chairpersons of their tribunals. And then you don't have lateral entry. I know this will take, you'll have to work both the systems together, what we have today and what I'm aiming at, what I feel should be aimed at. And then you have a system where the tribunal services themselves. And then those appellate tribunals, if they function properly, the high courts will not enter. You know, before L. Chandra Kumar's judgment, when the earlier judgment ruled the roost, then an appeal from then only an SLP lay against the order of the Administrative Tribunal to the Supreme Court. Initially, the persons who man the Central Administrative Tribunal, even I practiced before the Administrative Tribunal, they're of such high caliber that the courts would not interfere. Even after L. Chandra Kumar, it was not that as a normal rule that courts would interfere. But over a period of time, the quality of people being appointed has gone down. And more importantly, the number of vacancies is abysmally high. The tribunals, almost all tribunals across the country have huge vacancies. And we don't have a system of filling up these vacancies in advance. You see, the selection should be made. You know somebody is going to retire in 6 months or a year. Your selection process must start earlier. I've said that for High Court judges, it must start similarly for members of tribunal. It doesn't start. It comes at the last moment. And because of the judgments rendered, which I've referred to above in these cases, a number of these selection committees are headed by Supreme Court judges. But I'm sorry to say, though I've never been part of a committee, sometimes the recommendations of this committee are not implemented at all. They just, if they find that they don't want to appoint those persons, then that recommendation just lies in court storage for years and years or months and months, and the vacancy position keeps rising. When the vacancy position keeps rising, it has a snowballing effect. The snowballing effect is that new cases get filed, which can't be decided, and old cases get piled up. So by the time that, even if you appoint after 2 years or 3 years to full strength, it takes a couple of years just to start getting rid of the old cases, and by the time you handle those, you've retired. Because now the government intends that nobody should have more than a 3-year tenure. Because everybody is to come after retirement, so there will be a 3-year tenure. Now, 3-year tenure in a judicial service, in my opinion, is something which is a ridiculous act. Somebody who gains a lot of practice in the area is not going to, join. A good person will not join only for 3 years. And you'll get people who will join who will not be up to the mark. It is only if you have long tenures and appoint them at younger ages, at a younger age, that you will have tribunals which are functioning better. Another aspect which I'd like to touch upon is that these tribunals are not independent. In L. Chandra Kumar, a 7-judge bench laid down that they should be all come under one umbrella nodal agency, and they said till the government decides which is the nodal agency, it should be the Ministry of Law and Justice. That judgment has been flouted by the government, every government, always. So what happens is, if you are in a tribunal which deals with company matters, then the Ministry of Company is your boss in a way. Even the chairperson will have to apply to them for leave, for getting any perks, etc. If he wants a new vehicle. There is no independence. I'm not talking only about financial independence. There's no independence even to run the agency. Now, that compromises the independence of the tribunals. And therefore, I feel that is really something which needs to be addressed. The court has been saying it again and again, but again we uphold the same selections, and despite passing orders, they keep doing the same thing, and we've not done anything up till now. Because if there is one agency, it can have a standard format when we will have a test. Everywhere you can have a test now, like for judicial services, we've started having tests in advance. You can have a test in advance and you get services filled in. The other important issue is we must have I have said this in my judgment, that we must have a judicial impact assessment of which tribunals have done well, which tribunals have not done well. We have more than 30 or 40 tribunals. Some of them have hardly done any work at all. Some have done very great service. So somebody should make an assessment. It should be a judicial impact assessment made by a body of maybe retired judges or somebody who will assess along with the people from the government, because the administrator also has to look into it, and even somebody from the Ministry of Finance. Are we wasting money on these tribunals? Some of them. So you get these, and you then decide which tribunals should stay on, which tribunals can be merged together, because there are some tribunals which are almost overlapping with each other. They could all perform the same service and they can do it. So this sort of an assessment is required, I feel. And that can't be done by court orders or by judicial orders. That has to be done by actually examining the working. And that can only be done if there is one single nodal agency. Otherwise, you will have different parameters for everything. Now, the other very important access, which I feel, which tribunals have denied, I think I have about 7-8 minutes more.
Yes, sir. Yes.
So another important, access to justice is a fundamental. I have found that by making or establishing tribunals, access to justice is being denied to. Take the case of service tribunal. Take the case of service law. Before the Administrative Tribunals Act came into force, a PM or a clerk could file a case for redressal of his grievance before the concerned civil judge in his town or village. Tribunals were framed, the Central Tribunal with headquarters at Delhi, and for the northern states, I'm just giving an example because I'm not sure about the southern states, but in the northern states, the Chandigarh bench covers Himachal, the Union Territory of Jammu and Kashmir, the Union Territory of Ladakh, Punjab, Haryana, Chandigarh, at least 6-7 states. About 4 months back, and I think the situation is the same, it had only one member. It did not even have a bench. So what has happened, what was at one time a very good tribunal, is no longer a good tribunal. The other issue is, these people are being denied access to justice. You have an armed forces tribunal and your one bench at Chandigarh is non-functional. So everybody comes to Delhi. An officer of the armed forces can afford to come to Delhi and pay the fees of a lawyer in Delhi. But can a Jawan posted in Ladakh afford to come to Delhi? So we are effectually denying them access to justice. And I actually feel, and I've said this in my judgment, which is, I mean, it's not the majority, it's the minority judgment totally, that in such cases where a person does not have access to justice, he has a right to approach to the High Court under Article 226 and say that I have a right, because what is that is an alternative remedy. But it is not an effectual or alternative remedy, because I can't go to Delhi to file a case which I can do in Jammu or in Simla. So look at one of the tribunals which I think was really needed in the country is the Green Tribunal, NGT. Because this is a tribunal, this is beyond the ken of judges to decide all environmental matters. You need experts in the field. Today, it hardly has benches. So a person in Andaman or Nicobar Islands, a person in the Northeast, a person in Himachal Pradesh, Uttarakhand, Ladakh, which are the very ecologically sensitive parts of our country, who could have approached their high courts for redressal of their grievances. Somebody in Andaman and Nicobar could have gone to the local bench of the Calcutta High Court for redressal of the grievances. Now had to come to Calcutta to approach the NGT. Now I am told the Calcutta bench is also not functioning. So he has to come to Delhi. I was posted as Chief Justice of Chhattisgarh, which has a lot of ecological issues because Bastar, it has one of the biggest forest covers in the country. And it had no bench of the tribunal, you had to go to Bhopal. Now the Bhopal bench also does not function. So you are actually denying justice to the poor when you say that travel 500, 700, 1,000, 2,000 kilometers to go to an approach. The NGT has taken an initiative of saying that we'll entertain by video. See, we are also using, today also we're using Zoom, etc. But in environmental matters where a lot of evidence will have to be led, where a lot of issues will have to be decided, yes, video conferencing can be a tool, but it cannot be really the answer to all cases. It may be used, this is an emergency in COVID-19 days when we are, even the Supreme Court is using. But as I've said earlier, even with regard to the Supreme Court, all cases can't be decided. You can't have a constitution bench hearing on the on Zoom or any video app. You will have to have a hearing in court. Then we also have to have live streaming if you have to have people having access to the hearing. Because open hearing is an integral part of the independence of justice. And if you have a closed hearing between the tribunal and the lawyers, where there is no access to the public at large, then I don't think it's an open hearing in that sense. That is why what we've done now in the Supreme Court, very good efforts by the Honorable Chief Justice, is an emergency measure. But in the long term, we will have to find other matters. Yes, you can do some normal matters like pleading being completed, something record being completed by video conferencing. But when evidence has to be recorded, when final arguments have to be urged, I think by and large, mostly we have to have an oral hearing. I also feel that all tribunals, if they must be said to be effective alternative remedies, there should be a tribunal at every place where there is a high court bench. Otherwise, it cannot be said to be an alternate efficacious remedy. The other thing is that, lastly, just 2-3 minutes, I also have another suggestion that there should be a body to make appointments to the services, tribunal services. Like you have the UPSC, you could have a body comprising of both bureaucrats, technocrats, and retired judges of the Supreme Court or Chief Justice of the High Courts, who should frame the policies and should be as independent as the UPSC is while making recruitments to these tribunals. If you make recruitments in that way, then tribunals may be successful. Otherwise, I'm sorry, they cannot be said to be truly independent. I say it with a sense of sadness, but the functioning of many tribunals leaves much to be desired. Though at the same time, there are many tribunals which are doing great work. I mean, I don't have to name all of them, but some are doing it. So this is, the crux of the matter is that you must get the best talent into the tribunal services. No, first I'll just to cut it down, I'll point it down that one, first decide which tribunals should continue to function and which should not continue. Two, don't give all the work from the courts to the tribunals. There is some work which must be done by the courts, which the courts have been handling very well to now, and that cannot be just marked off to the tribunal. Anand, and there'll be a stage after 10 years or 15 years, if all these tribunals start functioning like this, that in the High Court you will have no lawyer or judge knowing company law. You will have no judge or lawyer knowing tax law. How will the High Courts then act as in the exercise of the powers of judicial review? Are the High Courts to be rendered only to decide civil suits and criminal cases? I'm sorry, this tribunalization must only be done where there are technical aspects involved which the courts may not be able to handle and which may require expert assistance. There I have no problem with tribunal, but then the membership, and then you must have a body which makes selections in a fair manner, objective manner, which lays down the rules. Nobody questions the impartiality or the ability of the UPSC. I don't think that we can't set up a body like this. In a country with 135 crore people, I think you can find a few judges, bureaucrats and technocrats who can man an institution like this very well and make the right selections. Then, as I said, a two-tier service, so that once there is an appellate provision in the service itself, then the High Court itself will be very reluctant to an exercise of its 226 powers to interfere, unless then then it does not act like an appellate authority. And then you don't have to go to the Supreme Court. Everything is going to the Supreme Court as an appeal. And a first appeal, virtually, some of us feel that a first appeal must be admitted as a matter of right. So all these things will have to be taken into consideration. But lastly, I can only say one line, that any system that you develop is only as good as the men who man the system. You can have no system and still have the best institutions, and you can have the best systems but not have good institutions if the men who man this institution lack integrity or lack dedication to them. Thank you very much.
Thank you, Justice Gupta. I think this has been a very, very exhaustive exposition, in fact, of various pieces of the working of the system. The key insight that I could really take is that we should stop looking at this as a very siloed thing of a tribunal versus the courts. And this is really a question of holistic integrating tribunals in such a way that as a dispute resolution machinery, the courts, judges, tribunals, and tribunal members all work in unison towards basically serving the larger goal of access to justice. And of course, wherever there is a need for a specialized input to come in, there I guess like other role. So I have a few questions. The first, of course, is the whole question of how much do we leave to the rules and rule-making power of the executive, right? Because this in many ways has been at the heart of some of these cases, including Rojer Mathew. Of course, you did mention that you don't want to get into your specific dissent, but mine is a more conceptual question as to how much should the parent statute lay down by way of detail, how much should really be fleshed out in the rules, and how much should be the leeway to courts to actually help out with framing institutions. And part of the reason I ask this question is because I see that courts have actually done a lot by way of laying down the parameters for setting up this institution. But is that because there is very little done in the Parent Act? And in which case, isn't it better if you just strike down the Parent Act and let the executive come back? Like, why is this sort of happening that there's a lot of getting done by these Supreme Court?
See, the question you asked me, I have to be forced to go back to Rojer Mathew. The guidelines were laid down in the various judgments, and if they were followed, then those guidelines would be followed. He struck down all of us, we were together on one thing, that the government action had to be struck down. Two of us believed, Justice Chandrachud and I, that it could not have been done by a finance act, but that matter has been referred to a larger bench. So I didn't go, though Justice Chandrachud gave detailed reasons, I didn't want to give detailed reasons. I just gave my preliminary view, because once it's being referred to a larger bench. But on this issue, I did not agree with the majority judgment, because in my view, I have said that this was an essential piece of legislation. and could not have been delegated. I won't go through all the judgments from Delhi laws to Hari Shankar Bagla and Ramesh Belt and all. But according to me, laying down the qualifications of the persons who will be eligible to be appointed to the such tribunals cannot be left to the rule-making body. It must be exercised by the legislative body itself. And why I say that is, could you imagine that the Constitution could have provided that High Court judges and the qualification for High Court judges and the Supreme Court judges will be laid down by the executive? The Constitution which lays down who's eligible to be a High Court judge. I mean, and it was not such a long, big job to do. It was because they were in a hurry. And by one stroke, they wanted to set aside all tribunals, change all the tribunals, change the conditions of all tribunals. That is why that happened. See, I quote something from my judgment, I'm sorry, I'm quoting. An analysis of section 184 clearly indicates that the Parliament has delegated to the central government the power to make rules to provide for the qualifications, appointment, terms of service, etc. I've said as far as their allowances, salaries, that could have been done. But what could not be done was their qualifications to be appointed. We are dealing with the appointment of chairpersons or public members to various tribunals. They are enjoined upon to discharge a constitutional function of delivering justice. What should be the essential qualification and attributes of persons selected to man such high posts is, in my view, an essential part of legislative functions. Don't want to read. So this is what I said. And I disagreed with as far as this was concerned, the entire court was together that yes, these parameters must be followed. Those parameters laid down in R.K. Jain, Madras Bar Association and Chandra Kumar, those parameters must be laid down. The Chief Justice said that it is expected that they will be followed. My view was, one would expect that the Union government to abide by the directions of this court. However, this expectation has been belied by this very enactment, which violates every principle of law laid down by this court, and as held in the judgments of both my brothers, the rules framed by the delegatee are violative of the law laid down by this court. So once you say that their legislation is violative of what we have said in our earlier judgments, how can we still expect them to say in rules to follow what we are saying? So that is my view. Therefore, I don't think this should have been delegated.
Right. I have one more question, which is on the aspect of specialized justice. And part of the reason I request a response is because we as technology policy people have been seeing a lot of this reliance on this buzzword, right? Specialization today. Aadhaar was a very good example, and now the data protection bill and the authority that they are seeking to create is another recent example. And in both these cases, what we are seeing is a lot of merging of functions. So it's not just adjudication, it's regulation of how the data is managed. For instance, like the Unique Identification Authority of India, right? It's a data custodian. It is also sort of agitating disputes on behalf of individuals who are aggrieved. Similarly, if you look at the Data Protection Bill, the Data Protection Authority has a very vast range of functions, including rule-making powers, and of course, in addition to that, adjudication, penalties, all of that. So these are I think some of this has happened post-liberalization already. The Telecom Regulatory Authority of India has a certain kind of mandate. SEBI has a certain kind of mandate. So this hybridization of multiple powers, and we began this conversation with separation of powers, and that's the reason why I would like to hear your thoughts. Today, that's really becoming exaggerated in the context of specialized functions and particularly technology. And COVID is another situation where I do foresee something like this happening. So in that context of hybridization of powers, using specialization as the justification, how much do you think separation of powers is going to really last?
That's a very important question, and I'm not very sure whether I'm really competent to answer all these questions, because I know very little about data protection bill, etc. at the present moment. But there is both SEBI, TRAI, or this. They have both. There are many bodies which have both adjudicatory roles and regulatory roles. In my view, normally I would prefer these bodies to be separate. regulatory body should not be also the adjudicatory body. But sometimes I'm not very sure about it. There may be certain occasions where it's very, very essential that they both are the same also. I'll assume for the sake of just assume that maybe for data protection and all, you need one body, both as a regulator as well as a adjudicator. But then should the regulator, but one thing should be very clear, that the regulator cannot be a judge in its own cause. It cannot start laying down regulations and then saying, now my regulations you violated, and then you see, that is where the problem is going to become. Because if I lay down the law, I will always feel the law is right, whether it's right or wrong. It's human nature. So that is where a big problem will arise. And and I'm saying this again, that whoever may be in power, this is one of the methods of controlling the adjudicatory process, to ensure that the adjudicatory process is not totally independent. But I am also absolutely clear that we judges can't say that we will decide everything. We are not competent to decide many, many cases. In fact, there was one judgment that only retired judges should be appointed as information commissioners. I was totally in disagreement with that. I mean, there are very good bureaucrats, technocrats who may be better in a better position to decide. So I'm not saying that they should not be appointed, but they should be appointed. But if, as far as possible, the adjudicatory role should be separated from the regulator. Because otherwise, there is going to be a clash, and there will be a lack of, once people lack faith in any adjudicatory body, then things start to crumble.
So you spoke quite a bit about the NGT, and there are quite a few questions here, Kaushal Modi and a bunch of other attendees. On your thoughts, and you have also been at the forefront of environmental justice delivery on multiple occasions, and therefore your thoughts on what has really happened with the NGT, and why is it that this whole breakdown has really occurred? Is it lack of political will? I think that there are many questions of.
I'm not saying, I won't say that there's any breakdown in the NGT. You see, every person, when any person heads an organization, he has a different point of view. As long as that point of view, like there is in cricketing terminology, as long as the umpire is consistent, anything outside the leg side is a no ball. There's nothing wrong. You see, we may not agree with everything. I may not agree with everything you say. You don't have a right to disagree with anything I say. The problem, you see, Justice Swatantra Kumar was really an activist who stretched the law to protect the environment. Now, under the new regime, what has happened is that there is a lot of, what I'm told, I have no personal knowledge, what I'm told, one, there are a lot of vacancies. Now, that is not in the hand of the chairperson. And a lot of hearings, I'm told, are being held by video conference where lawyers are not heard, and all of that is something they'll have to wake up there. But an NGT is a tribunal which was really called for. I filed as a lawyer my first environmental litigation, which was not the term PIL had not been coined at that stage in 1980, when I was a lawyer of 2 years standing. Now, and I had a very receptive Chief Justice, Justice V.D. Misra. The things which go across, you cannot decide in litigations. Many matters, you require recording of evidence. You require to visit the spot to see what is happening. You require to, really see what is a hands-on situation, because you have to balance environmental degradation with development also. It's very easy for some of us sitting in Delhi to say, having air conditioners on, having guzzling motorcycles and cars which guzzle fuel, to say that some trees should not be cut to take a road to a small village. We don't understand the point of view of that villager. When somebody in the family is unwell, they have to carry the person 8 kilometers to have a road. So why can't they have a road? So there has to be a balanced structure, and this can't be done in courts, in writ courts especially. So I think the NGT is a very good idea. It is one of the tribunals which must stay. It must be strengthened. It must be strengthened with the right people, with people who are engineers, technology, and good judges. Justice Goyal is taking a lot of good steps. I mean, some of his orders are very, but there is some other issues between him and the bar which I don't want to.
Similarly, there are a lot of questions on consumer rights. Again, another case, and I think much longer period of working, where a lot of attendees feel that even like updating a cost list, and I mean the whole process basically in multiple states are not really happening as per the way it should, especially for the ordinary consumer to get their grievance addressed.
I think consumer forums, the Consumer Protection Act, made with a lot of good intentions. And initially it did function quite well. It did function. I have, in fact, appeared before consumer fora in my state, in the Consumer Commission also. We are good retired High Court judges, effective judges, doing cases. And state to state may be a different ball game. But again, the problem there is, there are vacancies. In the national consumer, they're giving a date of 1 year. Why are they giving a date of 1 year? Because they've overloaded with cases. Now, if that, then how have you served the purpose of tribunalizing the courts? If their dispute had remained in court, you fix that consumer. Why can't it be said that all sub-judges or district judges will exercise the powers of the consumer court? They may increase their cases, but it is better than the NGT, better than what is happening in the consumer forum today. There are so many vacancies, and like in Himachal, I know where you have 12 districts, you have 4 consumer forums. Right. So why would somebody travel unless they go on a bench? Then they go on a travel from place to place. In states like Himachal, they have done it, and I am quite happy to say that they've done it in the beginning. They used to travel from place to place. It worked very well. But when I see at the national level, I find that the working is very, very poor. And this is one of the tribunals which I feel has actually failed. It was still about 4 or 5 years back, it was functioning really well, but now it has really gone. There's no head, there's nothing, it's just slowly dying out. It's very sad. So this was one consumer forum which was required. You see, because these fora were made with the intention that you will not go into technicalities. But then you appoint retired judges, a man who has worked as a lawyer, as a judge for 40 years. He just can't take technicalities out of his blood. You have to infuse new blood also. But this is a fora which is really not doing. As far as the NGT is concerned, it's not why it is because there are no members there. When I wrote the judgment, my figures may be wrong now, but when I wrote this judgment about 6 months back, right. You see, the NGT was set up with it to have a principal bench at Delhi and 4 zonal benches and 4 circuit benches. Right. It was expected at that time that more benches would be added. You see, it was 1 principal bench, 4 zonal benches, 4 circuit benches. That meant about 9 benches. Right. In my opinion, that was not sufficient. But it was expected that they would go over. Sadly, the reverse has taken place. At the present moment, only the principal bench is functioning with only 1 chairperson and 3 judicial members, as against a sanctioned strength of 20 judicial members, and 2 expert members as against a sanctioned strength of 20 expert members. So, as against 40 judicial and you have 5. Right. Now, you see, it's very easy to blame the chairperson of that why are you not giving us a longer hearing? Why are you not? Right. How does he do it? Now he is dealing with all the cases in the country which was expected to be done by 9 benches. And that is not his fault, it's the fault of the government. See, if I am overburdened 10 times with my work, then obviously the brunt will fall on the You know, when we have a miscellaneous day on Monday or Friday in the Supreme Court, we don't give more than 2 minutes.
Yes.
And that is what the tribunal, unfortunately, I would have liked they would have given a better hearing. But when this is the situation, how can they give you a much better?
So, I mean, talking of infusing young blood into the system, I mean, we have a lot of students here. So, I mean, just one final question. I mean, so many years spent at, obviously practicing law and then, on the bench. How have you seen the legal profession sort of evolve? And what would you sort of recommend to young students to sort of pick up and become better at the craft?
See, I spent 42 years, no, almost 42 years, 26 as a lawyer and about 16 as a judge. I've enjoyed every moment of it. Speaking for myself, both lawyer and judge, I've enjoyed every moment. And when you enjoy your job, it doesn't seem like a job. It seems like a pleasure. You know, you do your work. I think some of the essentials, I mean, I won't go into hard work, this, that, you all know that. But there's some other things which a lawyer must know. I talked about these yesterday in another. One which I learned from my senior, Mr. Kapil Dev, was that before you become a good lawyer, you must learn that you must be a good human being. You can't be a good judge, a member of a good, you may be successful, but you may not be good. There's a difference between successful and good. You must be able to understand the pain and anguish of your client. He comes to you with a problem. Can you solve this problem? Can you solve this problem quickly? Give him proper advice. I was very happy to note yesterday in another webinar that some young lawyers had started this system of pre-litigation resolution of disputes between themselves. I think that's a great idea. This is not arbitration, this is not mediation, this is something. This is a pre-resolution. You're a young lawyer, you get a notice issued by another young lawyer who's a friend of yours, and you can decide, why don't we sit together and take out. You must realize, yes, there's a big problem. Sometimes you feel fees, what happened, because you have to exist. I think it must be explained to the clients that if we help you resolve the disputes, you must pay us a much higher fee so that you're not filing appeals, etc., etc. We'll help you resolve the case. If that can be done, it'll be wonderful. I'm not sure how it'll work out, but if people have this intention, it can work out. I've seen it working out even when I was a lawyer, and it gives you immense pleasure. It gives you a sense of satisfaction which no victory in a court case gives you. Another thing is that you must broaden your horizons. You can't read only law books. You must read, or at least on Kindle read, or whatever, or on social media, whatever you have. You must keep yourself abreast with various other facets of life. Technology. I'm quite technologically challenged, though, especially when it comes to these latest things about data. Though I started using a computer in 1988, I was one of the, so that was at a time when a 286 with a 20 MB memory was thought to be the biggest, most advanced machine available. Now, but still, there are so many fields I don't know anything about. If you as youngsters keep yourself abreast with information technology, etc., you see, you will find this is a place where you can make a niche for yourself, where the seniors can't compete with. And you have to look at, and there are numerous new branches of law expanding where junior lawyers can. My other request to junior counsel is, don't think that you're going to practice only in the High Court or in the Supreme Court. 99% of the the litigants of this country, their interface with the judiciary it comes to an end with the district judiciary. You see, in these webinars and all, we mainly address lawyers who practice in the High Court and all. But the bulk of the lawyers work in the district judiciary. And they have to see that when they work in the district judiciary, how to carry it. Their work is a totally different ballgame than what we are discussing. And you must have some hobbies, some interests outside the law. You can't be tied down only to law. You must have some other varied interests. So that is what makes you a complete human being. And it's only if you're a complete human being that you can be a good lawyer or a good judge.
Thank you, sir, for sharing these life lessons in addition to your views on tribunals, which of course were really helpful to understand what is ailing the judicial system right now and what we need to do in order to reform many of these challenges that we face. And on a personal level, I'm extremely grateful to you for mentioning the needs for lawyers to reskill themselves and look at niche areas that are emerging. At the Daksha Fellowship, for instance, we are providing a technology policy pathway, we are providing a disputes resolution pathway, and a regulation pathway, all of which are really meant to help them skill one level higher than what they have learned in classrooms, and that's the whole mandate behind the fellowship. And to all our attendees, let me just mention once again that our second round of admission is underway. The deadline is on May 25th, so kindly go to the website, dakshafellowship.org, and fill in your applications. We have 100% tuition waivers before the second round ends, and make yourself eligible. Thank you once again, sir, for taking your valuable time out to address us and the students assembled here, and wish you the very best, and hope you have a great post-retirement life, which is very fulfilling and is as active as everything that you've done in the last 42 years.
Thank you so much. Thank you.
Thank you, sir.